With that, and without further ado, I'd really like to turn to the main focus of our discussion today. And so I am so pleased to have Professor Bruce Markell with us to talk about the concept of local authorities. Professor Markell is the professor of bankruptcy law and practice at Northwestern University Pritzker School of Law. Professor Markell has worn, I think, nearly all the hats one can wear as someone interested in bankruptcy law. He practiced bankruptcy law in Los Angeles. He's worked as a law professor and has written numerous case books and articles. He's also served as a U.S. bankruptcy judge for the District of Nevada. And he's nationally and internationally known and recognized. I'll paste a link to his bio in the chat because I couldn't summarize it in just a minute. It's just so notably, though, I did want to point out for purposes of today's conversation, when Professor Markell was a bankruptcy judge, he authored one of the most notable opinions on the question of when an entity in the US is a municipality for purposes of eligibility for our municipal bankruptcy system. So Professor Markell, thank you so much for joining us today.
Well, Laura, thank you so much for that very generous introduction and for the opportunity to speak. I appreciate it very much.
We're so glad to have you here. So just as a start, I was wondering if you could sort of provide a brief background on U.S. bankruptcy law and particularly on Chapter 9 of the Bankruptcy Code, which is the chapter, of course, designed to address municipal debt. So if you could just speak a little bit about that, particularly for our audience who may not have as deep knowledge of U.S. bankruptcy law.
And the problem with your request is brief. U.S. bankruptcy law is fairly broad and fairly comprehensive in its scope, and best understood, I think, through just a small sliver of history. And also, unfortunately, we're going to talk about things that I'm not the that aren't truly in my specific area, which is constitutional law. Because a lot of municipal bankruptcy runs from our Constitution. The Constitution has two clauses that matter for understanding bankruptcy. One is the Constitution specifically authorizes our Congress to create a uniform set of bankruptcy laws. Article 1, Section 8 of the Constitution gives Congress that power. Now, the interesting thing is it's not mandatory. For most of the first 125 years or so of this country, there was no federal bankruptcy law. It was mostly done by the individual states in terms of adjusting the debts of individuals and entities such as partnerships and growing groups as corporations. I'm talking mostly the 19th century. But there's another provision of the Constitution, the Contracts Clause, Article 1, Section 10, that prohibits states, and again, the United States is basically a federation of 50, 51, depending how you count, individual states, and the states are the source of most of our day-to-day law, the contract law, property law, as you wish. But it prohibits the state from interfering, I'll just say it broadly, interfering with contract. So, but it doesn't, that clause does not prohibit the federal government from interfering with contracts or changing contracts. So states and the laws they can enact in the United States are restricted in terms of adjusting, if you will, the liabilities under existing contracts, whereas federal law is not so restricted. And what that leads to, and again, we've had a continuous bankruptcy law in the United States since 1898. We've really only had reorganization generally since about 1934. And what that leads to is that the general provision of bankruptcy relief for entities, Chapter 11, has a little bit more power than what a state could do for its own particular insolvency regime. And in some states in the 19th century did have insolvency regimes. They just couldn't adjust contracts. They couldn't, we call them executory contracts. Contracts will still have some duties on both sides. And so one of the main distinctions between kind of Chapter 11 and what we call Chapter 9, which is for municipalities, is that ability to adjust contracts. Now, again, just by way of background, bankruptcy in the United States is primarily a consumer action. Literally 98.8% of all of the some 500,000 bankruptcy cases filed every year are consumers. Just a little over 1% are Chapter 11, and you can count on the fingers of two hands the number of Chapter 9 cases. There just aren't that many. But as with most law, most people deal with it by in the shadows, if you will. It's not the law that it causes them to do something. It's what they would have to do if the law were invoked. And so a lot of what Chapter 11 and a lot of what Chapter 9 in some respects does is to regulate individuals and entities, as to their activities because of what might happen to them otherwise. And so we start with the baseline, Chapter 11. Again, full-scale restructuring under a lot of consideration these days. But when in a Chapter 11, when a debtor files, say a corporation files Chapter 11, all of its assets become what we call property of the estate and are subject to the bankruptcy court's jurisdiction. There's an automatic stay that prohibits any creditor collection activity, and the stay operates without notice and without a request. It's just automatic. And there are various provisions to claw back actions, and primarily in Chapter 11, the ability to propose a plan that will adjust an entity's debts, typically by creditor vote. The vote's a little complicated. When the vote is taken, you only count those creditors who voted, and a plan is approved if each class of creditors approves it by a majority, more than a majority in number, when that majority holds at least 2/3 of the outstanding debt. The reason that's complicated is historically they blended two different types of things in 1978 because they couldn't figure out which one was which. And history has a long tail to tell here also about municipalities, because you can't understand a lot of what goes on in Chapter 11 unless you understand why it kind of came about that way. And so when I said 1934, that was the Great Depression. That was when Congress decided that it should federalize insolvency relief. Up until that point, insolvency relief had been more or less delegated to our equity courts through forms of receivership and through a tangle of judge-made rules, some of which actually were incorporated into the legislation. But at the same time, it was understood that different types of entities require different types of relief. The most basic notion is consumers require different relief than do corporations. But municipalities came in as well. And so what happens is that when I say Chapter 11, that can include individuals, usually high income because it's pricey, or high debt incomes, and corporations and partnerships and LLCs. And Chapter 9 includes municipalities, and we'll talk about what the code, the bankruptcy code here talks about municipalities in a little bit. But the way in which Chapter 9 was, the reason Chapter 9 became important was that it was recognized, especially during the Depression, that individual municipalities needed the type of relief that states could not grant. They needed relief that involved the ability to alter and get relief from contracts that didn't make sense anymore, or just to kind of shed some type of and restructure some type of debt. Now, that presented a problem. It presented a problem in the sense that, again, under our federal system, the states have powers that the federal government doesn't have. The federal government has powers that the states doesn't have. And that has to be mediated when, in fact, because there's very significant concerns that the federal government not invade the sovereignty of the individual states. This came up because the first Municipal Bankruptcy Act was actually declared unconstitutional by our Supreme Court in the 1930s because it was deemed to be too invasive. And so what happened was a political compromise, which kind of continues to this day, where Chapter 9 tends to look like a Chapter 11, but there are some very significant changes and alterations from a Chapter 11 practice in a Chapter 9. And I'll just outline them briefly, and then I'll stop droning on and let Laura ask me another question. But one of the things that happens in a Chapter 9 is there's an overriding concern that the federal government not require a municipality to tax its citizens or to invade the taxing or other sovereign powers of a state. And because of that, we're going to have lots of changes throughout. So what I want to wrap up is that Chapter 9 is available for what we call municipalities. And I want to, we'll talk about, the ins and outs of that. But one thing I want to kind of emphasize, states like California, New York, Michigan cannot file Chapter 9. They can't file Chapter 11. Our states are sovereign and they are not subject to any bankruptcy provisions. And indeed, that's came up with Puerto Rico because Puerto Rico is a commonwealth within the United States. It's not a state. And Congress believed and created a whole new statute, which incorporated a lot of the bankruptcy law just for Puerto Rico. And that action's ongoing. So we have this kind of, I want to say delicate balance, but I'm not sure how delicate it is, between the need for certain municipal relief and the need to preserve sovereignty. And then we can get into, excuse me, and Laura can ask me to go deeper, because again, a municipality here isn't necessarily what people would think of as a municipality elsewhere. It's more than a city, it's more than a county. But with that, Laura, you can direct me further.